Peace, family. As a practicing attorney for over 16 years, I've seen some things happen in the courtroom that it just turns my stomach and makes me realize that the system, as much as we would like it to change, that some things are just here to stay unless we do something radical. I wanted to talk about why is it difficult for blacks to be on juries? And why, as black people, do we run from being on juries? So those are two different issues that I want to talk about today. But let's talk about, there's a Supreme Court case that came down this year in May 2016. It was Foster v. Chapman. And in that Supreme Court case, which was decided 7-1, it was a black man who was on death row because of killing a woman in 1986. Now, during the jury process, his attorneys argued that he was discriminated against because the jury members who were black, or the potential jury members who were black, were struck. So they gathered evidence that they were able to show that, one, that they definitely identified that these particular jury members were singled out because of their race. They had different documents showing that they highlighted all the black jurors, or they put B by the name of the particular jurors who were black. And the court actually looked at this particular case and ruled in favor of the defendant. Although his case was vacated back to the trial court, his sentence still stands guilty. But these prosecutors have been exposed for their discriminatory acts. Now, that's just one case of many, and I'm glad that the Supreme Court ruled on that. But the sad reality is this has been going on for so long, and even though we may have a Supreme Court case, Batson versus Kentucky, that has ruled back in 1986 that race cannot be used as a eliminator in the jury pool, this still happens. Now, I did a little bit of research. Well, let me first break down how a jury panel is selected. Now, in a misdemeanor or in a felony, whether it's state or federal courts, you have so many spots for a jury member. And you may have a pool, it could be up to 60 people, 35 people, that is taken from a sample of the population. And most of these people are taken, are found through the voters registration. If you have a state ID, then you may be able to get a letter in the mail that says, you have jury duty. And a lot of times people run from jury duty and don't understand the significance of being on a jury panel. Why it's so significant? Because, one, you are determining whether someone either gets life or death. You're determining someone's freedom. You're determining whether someone is made whole or not. And if it was you in that position, you would want somebody to rule in your favor, or be somebody that is able to be fair on that particular jury panel. So, the institution of our civil process dealing with the jury panels, it's so important in our justice system. So I want to say that up front. But the issue that I'm talking about today is the fact that prosecutors have been able to circumvent the law, have been able to circumvent the Constitution in order to mete out that which is fair and that which is just. So, when deciding on the jury panel, the prosecutor and the defendants, they can strike jury members or potential jury members for cause. Cause meaning, they may know the defendant. Potential jury members may know the prosecutor. They may not be able to follow the letter of the law as it concerns deciding the case. They may not be able to give the death penalty, or they may not be able to give probation. So when we talk about cause, potential jury members can be struck because of cause. Now, the other thing is you have what you call peremptory strikes. Now, peremptory strikes are just what that is, that you can strike for whatever reason you deem rational to you. They may go to college, they may be short, they may be fat, they may be not enough education, they may be a Christian, they may be a Muslim. There's so many reasons why you can strike a jury member, a potential jury member. However, you cannot strike based on race, you cannot strike based on gender. But what we found out, and studies have shown, that prosecutors, in fact, have learned how to strike black jury members, and they will come up with neutral reasons in order to strike jury members that are of minority. Now, there was this study that, and I want to talk about it, a study that indicated that black jurors were struck more often than whites. And so there was a study of 300 felony trials in Cato Parish in Louisiana between 2003 and 2012, which showed that prosecutors used peremptory strikes against 46% of black jurors, while they used the peremptory strikes against 15% of the white jurors. Now, there were researchers at Michigan State University who examined 173 death penalty proceedings in North Carolina and documented that prosecutors struck 52.6% of eligible black jurors and only 25.7% of other eligible jurors, white, Hispanic, whatever. Now, in 2010, a report from the Equal Justice Initiative studied jury selection in 8 southern states and found that racial discrimination in jury selection persisted after Batson. Now, remember, Batson is the Supreme Court case that said that it is unconstitutional for jury members to be struck based on their race. So this study came after Batson, and what they found is that this study highlighted that prosecutors' offices explicitly train prosecutors to exclude racial minorities, and those prosecutors who discriminated did not face any charges. Now, there's another study that took place in Lake and Sarasota counties in Florida, where approximately 4 to 5% of their population is black. Now, in non-capital trials, they're decided by a 6-person jury, and typically the jury pool has between 25 to 30 members. Now, as a result, 36% of the jury pools in this study had no blacks on their jury panel or in their jury pool. Now, the result of this study indicated that the racial composition of the jury has a large effect on the conviction rate. So in the case with no black members in the jury pool, you can guess that black defendants were convicted in these particular counties 81% of the time. When you did not have any blacks on the jury, black defendants were convicted 81% of the time, while white defendants were only convicted 66% of the time. So having a jury panel that reflects the person's skin color is very important. The Constitution allots that you should have a jury of your peers. And what we've seen is that there are no juries of the peer of the black man or the black woman, because the statistics and studies have shown, and the injustices have shown, that this is not taking place. Although we may have Supreme Court cases that have come down with Batson v. Kentucky and Supreme Court case recently with Foster v. Chapman, you'll still have prosecutors who are going to do everything in their power to circumvent the law. So what are some of the solutions that, that we as law-abiding citizens, voters, what can we do in order to deter this particular type of behavior on jury panels? Well, one of the solutions was submitted by Supreme Court Justice Stephen Breyer, and he advocating eliminating the peremptory strikes. Now, there's some issues with that, because with peremptory strikes, if you have a case where you're dealing with somebody who's more heavy with the law, or somebody who's been involved in law enforcement, you may not want that person on your jury panel. So there's going to be some conflicts dealing with peremptory strikes and making sure that only strikes for causes are being used. The second solution is greater oversight and accountability of the prosecutors. Now, the prosecutors have so much, they're so powerful in the criminal justice system. They are the ones who go really unchecked. They can bring the cases. They decide whether the cases are dismissed or not. And so, but the problem is they're going unchecked. And so, you have counties in Texas and Dallas and Wharton County who, they specifically train their prosecutors, the district attorneys train their prosecutors how to circumvent the Batson rule in order to strike black jurors. Now, when we know this is unconstitutional, but it has happened, it has been documented. And so there have been training manuals that will list ways in order to circumvent the Batson rule. So you have to hold the prosecutors accountable. It's kind of like the blue code of silence with police officers. These prosecutors have to be held accountable. And when they see something bad happens, when they know something is happening like that, they need to come forward as a whistleblower and to speak out against this type of behavior. And so when we get into, as the police officers, they have this code of silence, prosecutors have it as well. So that code of silence has to break. In the case with the Foster v. Chapman case, the prosecutors, they were trained to do this. But for the defendants going after the documents, of their writing, their notes, their documentation, their jury selection documentation, they probably would have never saw this evidence that showed that the selection was not race neutral at all. Now, the third solution is to have has transparency. So what do I mean when I say transparency? Well, maybe the peremptory strikes and the cause strikes should be made public. So when you have something that's made public, more than likely when someone is watching you, you tend to do the right thing. So it's doubtful that many of the prosecutors will have kept track of these peremptory strikes, especially if they know they're doing it illegally. However, if you require them to keep track of it, and then you have the clerk who's able to record this, and they can do it in a cost-efficient manner, and you have it made open to the public, then more than likely you'll have less behavior or less room for these prosecutors who decide that they're going to strike Black juror members, and you'll see more jury panels that will be inclusive of the defendants. And 4, when a court determines that a prosecution or a prosecutor has engaged in impermissible strikes of jurors, then what we haven't seen in the past is the prosecutor being sanctioned for striking jurors illegally. So what needs to happen is every time a Batson motion has been granted and it has been shown that the prosecutor has struck a Black jury member or any jury member based on race illegally without cause and only based on race without race neutral reasons, then that person, that prosecutor, should be sanctioned through the bar. Not only sanctioned in the court as far as contempt, but also sanctioned through the bar. So here you need to maybe withdraw the peremptory strikes and just have it only for cause, but we still need to work those issues out. 2, you have to have oversight and accountability on the prosecutor. What are they teaching? What are they training? Are they training for diversity? Are they training for sensitivity? Or they're specifically training to circumvent the system? Now that this Supreme Court case has come down, then what you'll find is that now the prosecutor is not going to write the reason why they're striking this particular juror. They're just going to keep it up in their head. So we're not going to know the real reason why this is going to the jury member is going to be struck or not. The third thing is to have transparency again, to make sure that the prosecutor is being exposed and that all of his peremptory strikes are being made public. So when you have something that's public, then you're less likely to hide in the dark. And then finally, you have to hold them accountable. Sanction them. As soon as one of these motions are granted, then the court needs to find them in contempt, or there needs to be a grievance filed with that particular state bar. So we can't let this go unchecked. But the second part of this conversation I want to have is that many times I've had this question so many times that we as Black people, we run from jury duty. We do not want to participate in jury duty. One, the obvious reason is because one, we're going to get struck anyway. They're not going to allow us on the jury panel. We're going to be discriminated against. But the other thing is we refuse to vote. The jury pool comes from voter registration. It comes from, the state's ID pool. So let's register to vote. Let's get on those grand juries. The other thing is, because of our job situations, a lot of times it is difficult. It is taxing, financially taxing on us to skip work or miss many days of work to sit on a jury panel. So we'll figure out ways to avoid being on the jury panel. We'll figure out creative ways to be kicked off outside of, or race neutral ways rather, outside of because I'm just black. One, because we got to take care of our families. But it is against the law for your employer to fire you because you have been picked to be on a jury panel. Again, it is extremely important that we exercise our civic duty to be on juries because it could mean somebody's life or death, somebody's freedom. So I just want to encourage, those who hear my voice, put your name in the hat, register, check yes for jury duty, show up to jury duty, be present. So there is no reason to, to say that, well, there was nobody in the jury pool who was African American or who was Hispanic or who was some other race that wasn't on the panel. Be present. So when they do strike you, then you give the defense team an opportunity to raise that motion that something illegal happened. So again, I encourage you to exercise your civic duty, and we have to be vigilant. We have to stay vigilant, and we can't stop fighting for freedom, justice, and equality. Thank you.